Judge Goodman, thank you so much for joining us today. We're all very grateful for that.
Oh, thank you, Paul. I'm honored to be here, and I'm grateful for the opportunity.
Thank you. Rebecca Bandy and I have talked about interviewing certain jurists who have a rich history that can help us navigate these current waters. By that I mean the 24/7 cycle of everything, the social media, the pandemic, the quarantine, all those stresses that have been brought to bear on all of us. And I've always believed that the judges, the jurists, have such a critical role in keeping us on the right track, keeping the lawyers and the justice system on the right track. So I wanted to spend this time talking to you about your thoughts, your ideas, and maybe you can help us through this current minefield that we're dealing with. So with that as a short introduction, can you share with us why you decided that you wanted to become a judge?
There were several reasons. I was a law clerk to a federal judge, Judge William Terrell Hodges, when I graduated from law school, and got to see the inner workings of the court, and got to know very well Judge Hodges, who became a very wonderful mentor for me. And my wife was a judge on the state court bench, and it just was something I always wanted to do. And because I had enough knowledge and intimate knowledge of the inner workings of it, I was confident that I could do the job well. So I thought it was time for me to. I looked at it as doing public service and getting involved in trying to make things a little bit better.
Did you? What year was your investiture?
2007, January 2007.
And during your years as a judge, did you sit on the different divisions?
We here in the First Circuit have a criminal, civil, family, probate, and juvenile divisions. And I sat in all the divisions except family. I had to handle a few family law cases that other judges had to recuse from, but that was my only experience with family. But every other division I sat in while I was here in the First Circuit.
And I'm going to circle back on that in a bit to see how each division had different issues with either lawyers or clients, parties, etc., that the judge had to deal with. But before I get into that, let me ask you two things. One, you mentioned the federal judge as a mentor. Can you tell us what you learned from him, the lessons that you took with you through your career?
Judge Hodges was an extraordinarily intelligent gentleman, and he was also very dedicated to the rule of law, in that for him, what was important was getting it right, following the law, and letting the law tell him what the answer was, what there was to do. And it was very important for him when we were law clerks, and he was very close to all of his law clerks over the decades that he served on the bench. And he was very clear with the law clerks that we did not write an opinion until both he and the law clerk agreed that this was the right result in the matter that we were working on. And from that I learned, number one, getting it right, but number two, being humble, because there were times when Judge Hodges' initial feeling and my initial feeling were different. And after discussing it, Judge Hodges would come around to the way I saw things. And that was rare, I have to admit. But there were a few occasions where that happened. And quite frankly, a federal judge really doesn't have to listen to their law clerk. But he was keen to make sure that happened.
Are there other mentors that had the similar impact on you as he did?
When I first came on the bench, I was in the juvenile division in Escambia County. And there are two judges handling the juvenile division. We were in a separate courthouse. We were chambers right next to each other. And I was with Judge Ed Nickinson. And Judge Nickinson is really the senior, most looked up to juvenile judge in the state of Florida. Very, very intelligent, very knowledgeable, very meticulous. You would ask him a one-sentence question and get back a 14-paragraph answer. And it would be thorough and well-researched and perfectly helpful. And working alongside him was I was lucky. That's the easiest way to put it, because he was so open with me and so supportive of me and willing to help when I would hit a roadblock, because I hadn't done any juvenile law before I went on the bench, and it was all new to me, and I'm learning it all from scratch. And here I have this amazing resource, and he just was almost chomping at the bit for the opportunity to work with me and help guide me along. So he was an amazing mentor and still is an amazing friend.
Are there certain people that you meet with that you're a mentor to, that you try to carry forward the lessons they taught you?
Well, I've tried to mentor throughout my entire career. When I first started out, I had been a paralegal before I went to law school. So when I first started out as a lawyer, I was mentoring the paralegals at the firm. As I became more and more senior at the firm and younger lawyers came along, I tried to mentor them as well and be supportive and, not intrusive on the one hand, but on the other hand, make myself available in case they did have a problem or a question, and help them anticipate problems and questions. Then after I practiced for a dozen years, I went to the University of West Florida, served on the faculty there for 7 years. And of course, when you're on the faculty, you're mentoring all of your students. And then, since I've been on the bench, my son became a lawyer. He has several friends who are lawyers, and I was able to provide some mentoring to them over the years. So it's been a part of my method of operation, I guess, ever since I became a lawyer.
I know that you and I, our paths crossed years ago when we were both involved with the Professionalism Committee of the Florida Bar.
Right.
And I remember those days so fondly because we had some amazing giants that you and I worked with as newer lawyers. We were working with these giants. What was it about?
It was humbling.
What's that?
It was humbling.
It was. It really was. And I just soaked it all in. I just kept soaking it in. I was just this sponge. What is it about being involved in bar work that fulfills you or talks to you?
I feel like I'm contributing back to the profession that has given so much to me. I guess is the short answer to that question. Working with the Florida Bar, worked with the Professionalism Committee, and I was with several other committees over the years. Matter of fact, I'm still serving on a rules committee for juvenile rules. And it just feels to me like it's an obligation of any member of the Florida bar to contribute to the Florida bar and to have a hand in on what the decisions are that are being made, and contributing to the discussion. But the other side of that coin is you learn so much. You meet some amazing people. You work with the bar staff who I've never met a bar staff member who wasn't qualified, intelligent, enthusiastic, and amazingly supportive. And I've never been on a committee where there was rancor, there was disagreement, there was a lot of respectful disagreement, and there was a lot of debate. And there were times that my mind was changed by the argument that someone else made. And it's fulfilling to me to be able to have that interaction with such amazing people. Particularly as a younger lawyer, some of the lawyers that I work with who were more senior and more experienced, I should say more experienced rather than senior, and they were inspirational on the one hand. On the other hand, they were doing their homework. They were contributing. They weren't on a committee just to put it on their resume. It was something that was important to them. And that helped me feel better about putting the time in that it took. I mean, it's a time commitment. And we all know as lawyers that for every minute that we're doing something, there's 3 minutes more of work that we could be doing on something else. And parsing out your time is important. It's part of the survival process. Something that you learn over time is how to budget your time. And giving to the bar is something that I think you get more from than you give to, in that you do learn a tremendous amount. You meet some amazing people, you make some amazing connections, and you feel like you are helping make a positive difference in the bar and in the practice of law.
Yeah. I agree completely. Absolutely. I want to take us now to the courtroom. And because you clerked for a federal judge, you understood dramatically the differences between being a federal judge and being a state court judge.
Huge difference, yes.
Huge difference. Can you share with us just some examples of the huge difference between federal and state judges?
Well, on the federal bench, the stakes tend to be much higher in any particular case. That's not true for every case. I mean, there's some cases where, for example, we had a case involving an automobile accident with a mail truck, a U.S. mail truck, which is what gave it federal jurisdiction. And it was just like any other fender bender case that had to be tried. But most of the cases involve violations of federal criminal law. Most of the cases involve technical civil issues, not your run-of-the-mill breach of contract, but when you're talking about international contracts and things like that. So the stakes tended to be higher, and the decorum tended to be much more formalized on the federal bench. Plus, the federal judge has the advantage of having law clerks to assist and a staff at their disposal. A state judge has him or herself and a judicial assistant, and that's it. There is no other aid or assistance, and you're on your own when it comes to making decisions and working your docket and keeping everything up to date and moving. And the types of cases, depends upon what division that you're in, but the volume of cases that you have is substantially, I would say substantially, not hugely, but substantially larger on the state bench than it is on the federal bench. But the cases are larger on the federal bench, so those numbers are really deceptive if you just compare, numbers to numbers.
Yeah, so let's back up and talk about that then. If you're looking at the state court, you have, and you were talking about time and how important time is. You have a massive caseload. You have to move the cases along. Does that, to some extent, permit bad behavior by lawyers, easier access? Does bad behavior take place more in state court than federal court? I know this is not a scientific study, but just from your experience, do you see a difference in how the judges can address it or not address it?
Yes, the federal bench, I think by definition, is considered to be a higher level of practice than the state bench. And the amount of decorum in the actual courtroom. But for the most part, federal courts handle one case at a time, maybe several cases. But when you're talking about what I will call the cattle call type of case, first appearances, for example, things like that, the magistrate judge handles those. So the federal judge doesn't really have a lot of cattle call situations. The federal judge has the luxury of being able to deal with one case at a time, albeit much more complicated and much more demanding. On the state bench, I would have 75, 80 criminal defendants in for first appearance in what's supposed to be just an afternoon session. So I've got 3.5 hours to move 75 cases through from beginning to end and try to give everybody the best attention that I can give, make sure that I'm making the right decision, and make sure that the clients or the criminal defendants in that situation are getting their due as well as their due process. And because of a atmosphere of almost being a circus atmosphere, the lawyers have a lot more freedom to let their personalities shine through. And I mean that in a positive way as well as not a positive way. So I think that the level of practice in the state courts is going to be different, and that the lawyers are going to try to get away with more behavior, more cutting edge behavior, and again, good way, bad way, in the state court than you're going to see on the federal bench.
How did you handle, did you have a process or a protocol that you followed in state court as a judge in dealing with bad behavior? Did you meet with the lawyers beforehand? Did you have let's stop here for a second and we have to have a talk? Was there any protocol that you followed when you saw it going off the rails or someone taking advantage of the system?
Understand it's different in each division. In the civil division, your cases tend to be more one-on-one. You have time to work with the lawyers on doing the pretrial conference. You have time to work with the lawyers on doing the discovery plan. And the level of participation and interaction between the judge and the lawyer is much different. But I'm going to see some of these lawyers once and only once in the civil arena. In the criminal case, I've got the public defender or two. I've got the state attorney or two who are in my division or any criminal division. I mean, that's the way they're all set up. And these lawyers work with me on a daily basis. The only other lawyers that we deal with are the private hired criminal defense lawyers. And a lot of those lawyers came from the ranks of state attorneys or public defenders. So when you're dealing with the same lawyers day in and day out on a regular basis, it tends to get to the situation where the lawyers know the judge, and rule number one, know your judge, and where the judge gets to know the lawyers and their strengths and weaknesses, and the lawyers that you can take their word to the bank, and the lawyers where you sometimes want to question a little bit more closely just to satisfy yourself that you're getting all the information that you need. But the criminal bench, the community of lawyers is much smaller, much more constant. You see them on a much more regular basis. In juvenile, you got the same kind of situation where you've got the attorney for the Department of Children and Families, you've got the attorney for the family, you've got the attorney for the guardian ad litem, and these attorneys are literally in your court for 1 or 2 days a week, every week in and out. And you get to know them very well. They get to know you very well. The nature, though, of juvenile is let's fix the problem. Let's try to figure out what's going on here and why. Whereas in criminal, you're looking at, okay, was there a crime? If there was a crime, what's the appropriate punishment? In juvenile, you're trying to fix the family, put the family back together, identify what's the problem that got us here, and do what's necessary to get the family back together. So it's much more cooperative environment between the lawyers, all the lawyers, and the court, because we're trying to figure out, a lot of cases involve drugs, and we would get drug therapy to the parent or parents who were involved with the drugs. And many, many, many times we were successful, and the parents got off the drugs and the family was reunified and hopefully stayed on a very good course. There were very few of those cases that would come back and be repeaters in the family law area, in the dependency area. So, that was a different environment as well. So the lawyers there tended to be a constant factor, and misbehavior was not anything that you were going to see in the dependency area. Delinquency, again, you have the state attorney, you have the public defender, and you had the private counsel who would come in from time to time. And very rarely were there professionalism issues at the delinquency area, because the stakes didn't tend to be as high, number one. And number two, most of the lawyers who practiced in that area were very experienced in that area and knew what they were doing and knew what they were asking for. And pretty much it was a cooperative as opposed to a confrontational situation. Of course, there were times when the lawyers were confrontational because they disagreed on what was going on, or there was a trial, or there was a matter to dispute. But for the most part, it was, let's figure out what's going on with this juvenile. What are the facts? What's the appropriate remedy? And here, the remedy is not punishment, but the remedy is supposed to be rehabilitation. So different divisions, different natures. The lawyers tend to behave differently depending upon the division and the circumstance.
So with that as a backdrop then, let's focus on the civil division, because the civil division seems to be, from my experiences, and I would think your experiences, the area where you have more of the professionalism, civility, and ethical issues than the others.
That was my experience. I can only say that as anecdotal, but the most unprofessional conduct I experienced was in the civil division. Some of it was lawyers who just, it's okay to push the edge of the envelope. It's another thing to just blow past it without any regard for what's going on. And most of the time, that's where I would have to, call a lawyer up to the bench and have a serious conversation about, okay, let's tone this down. Let's reel this in a little bit. I know where you're going with this, but the way you're doing it is not effective, and you're not helping your cause by doing it this way. Let's try this again. And that usually did the job.
What we have heard and what we see is that a lot of issues on professionalism, civility, and ethics occur outside the courtroom. They happen during the discovery process, production, depositions, email exchanges, text exchanges have become quite their own area of study these days. How involved did you get, or you think the jurist should get, in when a discovery dispute comes to you that the ball is being hidden, or they're delaying, or they're stalling to prevent a deposition from taking place? Examples like that. How involved do you get in? Do you have the time and inclination to delve into that?
I think you have to. I think you have to address it when it's presented to you, and you have to take it seriously, and you have to make sure that this is the type of action that's not going to be repeated. The lawyers are going to raise the issues. The judge is going to hear about it one way or the other. So if you're acting improperly in a deposition, if you're not producing documents on a timely basis, if you're holding back information that rightfully needs to be produced, the judge is going to hear about it, and we don't appreciate it. I can't speak for all judges when I say we don't appreciate it, but I think most judges would agree with me that what we want to be doing is, what are the facts, what's the law, what decision does the judge need to make? And when it gets down to picayune disputes over particular questions of the deposition that the lawyers couldn't get together and work out amongst themselves, it's not appreciated by the court, because this is something that the lawyers really should be handling on their own. And the other side of that coin is, if you're acting that way, the judge is going to hear about it, because the other side is going to bring a motion about it, and there's going to be a hearing, and the judge is going to see it, and the judge is going to know this is the way you acted under this particular circumstances, and you're now going to have that label from that point forward with that particular judge. The problem is, in some of the larger jurisdictions, here up in the First Circuit, it's a smaller bar. The lawyers tend to be in front of the judges on a much more regular basis, and the lawyers and the judges tend to know each other much better and have an opportunity. But in some of the larger circuits, where you've got literally hundreds of circuit court judges, a lawyer may see a judge on one case and never see that judge again. And the lawyer may take the attitude with this particular judge, I don't care if this judge gets mad at me. I'm going to do this because this is going to give me an advantage in this case, and it's not going to have repercussions down the road. The problem with that logic is judges talk. We talk to each other. And when we've got a lawyer who is acting outside of the pale, we tend to talk to each other about that particular lawyer. Usually in the situation where you'll find out another judge handled another case with this lawyer, and you'll contact that judge and say, this lawyer acted this way in front of me. Is it me, or is this the way the lawyer acts all the time? Because the judge reasonably wants to know, why is this lawyer acting out in my court? Is there something that I did or didn't do, or should or shouldn't do as a result? So we don't talk to each other by way of just plain old gossip. We talk to each other because we want to find out, okay, did I do the right thing? Did I appropriately assess the situation here? Was this situation totally unusual for this lawyer, or is this the way the lawyer conducts themselves all the time? So even though you may see a particular judge only once in your career, there's going to come a point in time where another judge is going to ask that judge, have you ever had a problem with this lawyer? And I think judges tend to have long memories, and so it's going to come back to haunt you one way or the other.
So continuing on this train of thought, In your courtroom, in the state courtrooms in Florida, they have that sign over the bench. We who labor here seek only the truth. I think it says something like that. I'm close to it. What does that mean to you?
To me, that's not an ideal. It's not a, we seek the truth, wink, nod, okay, let's go about our business. To me, it's important to find out, what really are the facts here, what really happened, what are really the items in dispute, the issues that need to be decided, and get to the bottom of it and to get it decided and get it decided right. You can't always be right. You're not always going to be right. And, that's why they're courts of appeals. You don't take that attitude of, I don't care whether I'm right or not. The Court of Appeals, if I'm wrong, is going to fix it. But you take the attitude of, I want to do it right every time to the largest extent that I can do it. I want to get it right. I want to understand the facts. And I want to make sure that everybody in the courtroom walks away feeling that they had a fair hearing and that the judge listened to them and paid attention to them. And whether the judge accepted their side or not, that at least they got a fair opportunity to present their arguments on their side and present the what they thought were the persuasive facts on their side. So it's the guiding principle. It's not just a pie in the sky ideal. It's really what I think. I can speak for myself personally, but I think for many of the other judges that I worked with over the years, they really labored to try to get it right. It was important to try to get it right for no other reason than that's why they became a judge.
Yeah, and so drilling down on that further, we have state court judges that have a massive caseload. I assume, and you can fill us in on this, that the state judges are, I'll use the word monitored, but monitored with their caseloads, closing cases out with a certain time period or a structure like that. So you have to move the cases along. And then you have that other ingredient that you don't have in federal. You have judges who are elected and the pressure of running for office. And can you share with us your thoughts on how the caseloads, the time constraints to close cases out, the election of judges, how that impacts, if at all, I can't ask you to speak for judges, but I'm just asking your thoughts on how that impacts being a judge.
Okay. It's a fair question. It's a fair question, and I think there's several responses to that. I can really only speak for me personally. In terms of moving the docket, it's a balancing act between, okay, here's a case that I need to spend a little bit more time on versus this is a routine. I've seen this case 150 times already this week. I know exactly what the lawyers are going to argue. I know what the fact situation is. There's no search and seizure issue. There's no due process issues. The facts are pretty clear, and the result is pretty clear. Let's handle it and move it along. But you've got to be on guard for those cases that are not the norm, the cases that are the square pegs for the round hole. And you have to really pay attention on those cases and give them the additional time that they need, although that's going to back your docket up. But that's just part of the process. You have to accept that. In terms of the re-election issue, my own personal philosophy was, as long as I labored hard to do my best to get it right, and as long as I kept my docket moving in as reasonable a manner as I could, that I would let the election matter handle itself. I ran for election the first time, and the next two times that I was elected, I drew no opposition. So, for me, it was never really a real challenge that came up. I understand from talking with other judges from other parts of the state, the more metropolitan areas, that there's that competition, and there's the very expensive campaigns and the very expensive in terms of time that has to be put in. And then you have all the ethical restrictions that you have in running for office that makes it very, very difficult. And if you get somebody angry enough, they themselves or they will find someone else to run against you. And that's part of the job. And it comes with the job. And in my opinion, you simply have to focus on doing your job, doing your best to get it right, keep it moving along at a reasonable pace, and let the other chips fall where they may. But that may be naive on my part because I never had to face opposition. And I'm not in a large metropolitan area. From the judges who are in the large metropolitan areas, they feel that pressure, but I would say 95% of the judges would talk about, yes, I feel that pressure, but I can't let that affect what I'm doing. I can't let that affect the decision I make in a particular case or for a particular lawyer. I have to go about doing my job and again, let the chips fall where they may. There's some judges who are very aware of the reelection, very aware of the public perception. And does that color their decision-making process? Does that get in the way of we who labor here seek only the truth? I can only say maybe. I don't know of any one particular situation where that occurred. I've heard rumors of that, and I've spoken with judges who have talked about the pressures that they've had, but I've never seen or heard of a particular situation where a judge's decision was consciously different because of the fear of drawing opposition in an election. That's a pretty long-winded answer to that without a whole lot of information.
No, I really appreciate it because it leads me to this next topic, which you and I have briefly discussed about in the past, and that is this topic of active and passive injustice. So let me lay that out a little bit for you and see if you want to run with it at all. It has been said that many lawyers will act unprofessionally or not civilly or have ethical issues because it's not a standalone issue. They're doing it for a purpose. They want to hide the ball or prevent discovery or delay for whatever reasons, and the justice is not being done. And we've talked about, the fact that the judge is the gatekeeper to make certain that it is going to be a just trial. And if a judge, for whatever reason, doesn't get into the mix of straightening it out, is that judge engaged in what we call passive injustice, not doing something and therefore letting the active injustice continue. I know that's a rambling statement and going to be a question, but can you pick up on that and just give your thoughts about the responsibility of the judge to make certain that the justice system is functioning?
The etymology of the term gatekeeper goes back to a short story by Franz Kafka. And it's a story that I used many, many times in class to help the students understand the sometimes ununderstandable situations that you will find yourself in the law. If you haven't read it, you need to read it. I think every lawyer should read it in law school. But if they haven't read it in law school, they certainly need to read it to understand and you can identify with the frustrations of the person who's trying to get past the gatekeeper to get to the law, to get to some type of resolution of what's going on. But Kafka aside, the gatekeeper function of the judge it's real. It is part of the job, and like we were talking about earlier, with which cases need to have which are the most attention, and those cases that maybe can deal with less attention. The lawyers, at the same time, they're trying to win their cases. And sometimes that motivation to win the case overcomes their professionalism and their obligation that they have to sometimes do things that their client's not going to be happy with. When you have to produce documents and those documents are not good for your client, your client sometimes will turn to you and say, well, isn't there some way we can hold that back? I mean, aren't there ways that lawyers can file motions or something? And they don't really understand, no, I don't have a choice here. I'm obligated to do this. But because the client may be so insistent, the lawyer may withhold the document or file a motion to suppress in court in such a way that at least they can delay the production of the document for as long as possible. And sometimes they'll hide the document. I mean, literal story. I'm a paralegal. We are sent to the home office of the client in an antitrust case, and we are up in an attic going through old documents for a good 10 days. And at the end of that 10-day period, I'm the paralegal who's left behind to oversee the production of the documents that we selected that we thought were responsive to the request for production. My job is to oversee the production. So before the lawyers left, because it was lawyers and paralegals who were doing this work, one of the lawyers went to the boxes of documents that we had that were perfectly well arranged, in perfect order. I thought that's what we were supposed to do, and just started mixing up the files like you would shuffle a deck of cards. And I got the sense that this is not right. But as a lowly paralegal, the last thing I was going to do was turn to the lawyer and say, are you sure that's ethical? And I was never comfortable with that. Why did the lawyer do that? I mean, all the documents that we produced were being produced. I mean, she wasn't taking anything away from there. She was just putting everything in a different order to make it a little bit more difficult for the other side. And I still to this day remember that vividly and ask myself, why? What good was accomplished by doing that? And the other side of that coin is, you think the other side wouldn't figure out really quickly that these documents are out of order and someone must have played with them, and let's spend a couple of hours and see if we can't put them back in order, which is exactly what they did. And nothing was accomplished other than one side got the impression that the other side was playing loose and unethical. So lawyers will do things like that without really thinking it through and without understanding that they're going to get caught. I mean, it's going to get noticed. It's going to get seen. That document's going to show up at some point in time. Some person in a deposition is going to refer to that document, and you're going to have to answer questions about why that wasn't produced when it was completely, clearly relevant to the request for production. But the lawyer is risking, by playing games like that, you're literally risking your license. Because, that comes before the judge can discipline you. That discipline can be sent to the grievance committee, and then it can go all the way up to the board of governors. And the next thing you know, you're standing there in front of the Florida Supreme Court justices trying to explain why you shuffled the documents. So, it's a game. It's not one. It's a zero sum game, I guess is the best way to put it. You're not going to win.
Yeah, exactly right. So when you saw situations like that take place, they were brought to your attention. You would be an active participant in trying to solve the problem and get the case back on track, as opposed to saying, I'm too busy, I'm up for election, I don't need this problem, I don't need this trouble right now. That was you were someone who said, and you would tell newer judges, let's say, this is what you signed up for, this is the job.
I mean, yeah, it's what the sign says. We who work here seek the truth. And it's what you sign up for. It's what your job is. And you do have to pay attention to it. And you do have to attend to it when it happens. And in appropriate situations, you have to sanction it and or refer it to a grievance committee. That's the job description.
Judge, I'm at a certain age where I reflect. I do the look back on things I've learned, things I wish I would have learned sooner, but things I've learned over time. As you look back over your career, you still have a long career to go, but as you look back over that part of your career, are there certain things that that you consider as, this is what I've taught of, this is my legacy, this is what I would like people to think about when they say, so do you know Judge Goodman? Yes. Tell me about him. What would you like that to be?
What I would like that to be is he did his job and did his best. He wasn't perfect. I'm not perfect. I didn't do everything perfect. And as I look back, there are some decisions that I've made that I've come to say, I'm not so sure that was the right decision, or maybe I could have made a better decision. But I would like people to at least view me as someone who labored as hard as possible to do the right thing and get it done correctly, to do justice. That's what my focus was, and that's what I did. Not that I'm anything special, not that I'm some super judge or deserve any kind of great accolades. Just that I did my job, and if that's the reputation that I have, then I'm happy with that.
So, believe it or not, we've been going quite a while. Time goes fast when you're enjoying yourself, and I'm so enjoying speaking with you, and I'm very grateful that you took the time.
As am I.
Do you have any particular core beliefs that help you get through bad parts of the day? Do you have any certain philosophy of life that helps you when dark clouds are rolling in at all?
Well, I have my wife, and she is an extraordinarily grounded human being. And I don't know if I went home to someone who was not in the law and someone who had not been a judge, that I could get the same kind of help and assistance that I got from being able to come home and talk to my wife and say, you're not going to believe what happened today, or, this happened today and I'm not sure, what was going on here. And she just had the experience and the knowledge, and again, the foundation that she was able to just help me think it through and figure out, where things are going or why they went the way they did. So that was just a tremendous resource for me. And then the other thing, in judicial college, they have a certain number of classes, and one of the classes they had was on mindfulness. And I had heard of it. I didn't really know what it was, but there were, several people who had mentioned how mindfulness was helpful to them. Make a long story short, I went to the class in Florida, Judicial College. I found that it was interesting. I was most interested by the physiological changes in the brain that came from mindfulness. So I took a 1-week course on mindfulness that was very intense and worked very hard. And I learned how to quiet my mind at the end of the day. And I would it was just 10 minutes at the end of the day, and I would go to a quiet spot, usually a rocking chair if I could find one, and it's just an exercise of clearing the mind, of being able to take that 10 minutes and quiet all those voices that are going on inside and all that. Okay, I need to do this. I need to do this. This is what's coming up, things like that. And you just quiet your mind for 10 minutes. If you can do that and do it effectively, when you finish that process, then there's a clear cut between, okay, I've come home and now I'm home. Now I'm ready to just be me and not be the judge. And that, to me, became a tremendous aid during my career. And I think lawyers could benefit from that as well. I don't have time here to go into all the details of what mindfulness is, but it's not difficult. It's not hard. It's something that everybody can do. You don't need a special mat. You don't chant any mantras. You don't, have incense going or anything like this. You literally find a quiet spot and 10 minutes of time and clear your mind and let everything, go. It was explained to me during one of the courses that you'll never completely clear your mind. That's not going to happen. But what you learn to do is, oh, there's a thought, let it go. Oh, there's another thought, let it go. And that just that 10 minutes provides that separation so that your perspective, gets back to just being a human being. And not that lawyers are not human beings, but when you're being a lawyer, your senses are shooting, your mind is going, everything is rolling. You're thinking about this and that, and what's this consequence, and what's that possible consequence, and how should I have done this, and how do I do this next, and what's next on my calendar, and it's so easy to get so caught up in that 24/7, 365, you're going to burn out. And as a judge, it's the same thing. You're constantly worrying about your docket, constantly worrying about the decisions you made and the decisions you got coming up. And if you can have that separation, it just gives you a better perspective so that, okay, now I'm ready. Okay, what's the next thing on my list? And then you just get back to what you need to do. So that's been very helpful to me.
No, this was very helpful, and I thank you. So as we kind of wrap this up, I guess one of the takeaways, and I'd like you to address this if you could, as however you'd like. I always thought that all of us can either add to the problem or be part of the solution. And I think that as lawyers and judges, one of the reasons we became a lawyer and a judge is because we wanted to help people find the solution. We didn't want to make the problem worse. We wanted to find the solution. And I think sometimes that may be lost in the daily back and forth of, because litigation is an adversary system. So the bottom line, though, is trying to find the solution. Can you just share your thoughts as we wrap this up on being someone who's asking lawyers and asking yourself to find the solution as opposed to just adding to the problem?
Well, two things. I'm going to quote President Kennedy: "If you're not part of the solution, you're part of the problem." And I think that's a truism that's proven itself time and time again. The other answer I have to that is when you're up to your rear end in alligators, it's hard to remember that you went out there to drain the swamp. And I understand that, but you have to realize, why am I doing this? It may be an adversarial system, but it's an adversarial system designed to reach the truth, designed to reach a reasonable resolution to the parties, and designed to achieve justice. And you can get so caught up in the adversarial part that you lose sight of, this is a justice system, and this is what we're supposed to be doing, is seeking justice and doing justice and achieving justice. And at the end of the day, when the case is over and all the dust settles and everything goes away, if you can say, I gave it my all and did the best that I could, but I did it the right way. And I may agree or disagree with the result, but at least the process was fair, and my client had a fair shot at arguing their point. But not everybody can win, not everybody can lose, and sometimes the difference between winning and losing can be a judge's interpretation of one sentence in a contract. Even though you've got 600 different issues going back and forth and up and down, it's that one sentence that the judge says, well, because this is what the law says and this is what was in the contract, this is the way I have to decide the case. You can't change that. That sentence is not going to go away. The case that's on all fours is not going to go away, and you have to accept that and go on.
Absolutely. Well, we have gone for about an hour, believe it or not. It always goes by fast when I'm enjoying it so, speaking to you. I thank you for your time. I thank you for your wisdom. We're choosing people to talk to that have a certain grace and wisdom about them, and you definitely are there. And so thank you very much for your time. And any other final thoughts you have, I'll give it to you.
Well, first I want to thank you for this opportunity, Paul. You've really done a wonderful job, and I've enjoyed this thoroughly. I guess my final parting thought is, it may sound naive, but if you can continue throughout your career to remember why you're doing this, what motivated you in the first place, then that guiding principle is going to help you many, many, many times get through the many challenges that we face in our profession. But it's a great profession, and there's some great people, and there's some great achievements that have been made, and there are great achievements yet to come. And to the less experienced lawyer, let me just tell you, it's worth it. All that hard work, all that sweat. When all is said and done, you feel better about yourself, and you feel like you have made a difference. And in the overall scheme of the world, we're all going to pass away at some point in time. The question is, did we make a difference between that day that we were born and that day that we pass on? And this profession gives you a unique opportunity to really make a positive difference in the world.
Thank you so much. I'm very grateful. I wish you only the best, Judge.
Thank you, Paul.
Thank you.
You take care as well.